15,000 megawatts of power in Japan within 90 seconds. That's a huge cost. When the costs are coming in at $23 billion in damages and we have a $12 billion liability in the United States, that's a cost. If we have to shut these plants down, we need to know how we're going to replace these things, how we're going to start to plan to replace 4,400 megawatts of power, 2,200 in the north, 2,200 in the south. We need to know those things, and those things should proceed. We should certainly go ahead with what happens if we don't continue to operate these plants. But that's not what this proceeding is about. PG&E wants money for a license renewal. PG&E wants money now for a license renewal they may never get. And they want to tie it to a number that they're not even willing to tie themselves to. This is about costs. This is about what it's going to cost for ratepayers to either assume we're going to have 2,400 megawatts of nuclear power or assume that we're not going to have 2,200 megawatts of power. When we went to the Energy Commission in 2005 and said, you do a review every 2 years of what energy needs are out there in the future, but you don't seem to be looking at nuclear power. That's 4,000 baseload megawatts of power. Why aren't you looking at that? And they said, oh, we should be doing that. And they brought everyone together and they looked at the cost, benefits, and risks. And all of those things should have been part of this proceeding to make sure that we're building on a record of what are the costs, what are the benefits, what are the risks, how can we replace that? Instead, we're limiting scope. We're talking about aging components, which this commission has very little oversight over except for how much they cost. And we don't know what aging components are going to be there in 3 years. We didn't expect to have to replace steam generators, turbine rotors, reactor vessel heads in the original life of this plant. In fact, we were told all those parts were going to last the full life of the plant, but we've replaced them all. So knowing in 3 years what's going to happen in a nuclear power plant, we don't know. We didn't know 3 months ago what was going to happen in a nuclear power plant. We need to pull this off the table, to dismiss this application because it doesn't have any relevance to what they're going to come back with in 3 years or 4 years, or if they ever come back. It could be that the NRC decides, the retrofits are going to be, so great, it's going to be a Humboldt scenario, and it's just not going to be cost effective to do the retrofits. We don't know the answers to those questions, and I'm not saying those are the answers to those questions. But their license isn't up until 2025. They could have started these studies sooner. They should have started these studies sooner, but they didn't. Everybody just said, oh, we'll just go along business as usual because it worked in the past. Oh, and we can come back later and ask for more money because, hey, it's worked in the past. Well, I'm just asking to have it not work that way any longer. I'm just asking to be as reasonable and prudent as we can possibly be when it comes to aging nuclear power plants sitting on seismically active coasts that are very, very labor intensive to rebuild, and you couldn't rebuild one there if you wanted to. It would take time and effort to replace them. Those are the types of things that we want to know. PG&E didn't put those in an application. Their application says wind from Montana and Wyoming. It has nothing about how you would do that in the state of California. It says it's $80 million is reasonable for a license renewal application. I don't know if $80 million is, but I guarantee it's not going to be a reasonable number in 2015. It just won't be a reasonable number in 2015. And I'm tired of being proven right. Over and over again, I said, stop, look, let's be a little more careful with this. And over and over again, we'll deal with it when we have to. We'll just move that little thing on down the road. It's not a little thing. It's a huge radioactive elephant sitting on a seismically active coast. And investing in that has to be a decision made by this commission and this commission alone. And to just open proceedings so we can all ask questions over the next 3 years and then bring that same document back again. I see no relevance whatsoever, just absolutely none. And there isn't another person in this room who sat here as long as I've had. I have to hear every one of these proceedings and how they've all gone and how they've had to be redone again, except for maybe Mr. Florio, because he's been around forever too. But, basically, Judge Barnett, you have been around forever. You didn't have to say it. You're right. We are aging beautifully together. But we do need to now just give ourselves a shot of reality and say this is absurd. They understood from the very first pre-hearing conference that one of the big issues was whether or not this proceeding should go forward absent the completion of these seismic studies and the resolution of and the review of these seismic studies. That's been on the table all along, and it's just not on the table for Diablo Canyon. It's also on the table for San Onofre. And while we hope that they get their seismic studies going, and we're glad to see them file, they're a long way away from completing their seismic studies as well. And if they come in with an application absent the completion of those studies and the review of those studies, we're going to find ourselves in the same position again.
All right. I think we have heard enough. I want to point out one factor that has not been discussed by any of the attorneys who practice before this commission on a regular basis. And I want to cite you to section 1701.5 of the Public Utilities Code. And this is obviously a legislative section. And it says, in a rate setting or quasi-legislative case, and this is a rate setting case, the Commission shall resolve the issues raised in the scoping memo within 18 months of the date of the scoping memo, unless the Commission makes a written determination that the deadline cannot be met. Well, the scoping memo in this case was filed June 23rd, 2010. 18 months from that date to resolve the issues raised in the scoping memo. Unless the Commission makes a written determination that the deadline cannot be met, including findings as to the reason, and issues an order extending the deadline, that's the Commission issuing an order extending the deadline. No single order may extend the deadline for more than 60 days. Now that means that we have to do this every 60 days until someone decides to put this back on the calendar. And 2015 is the day. We're talking about 3 or 4 years. That's 6 times a year we have to issue an order. And this is just ridiculous.
I was under the understanding that the applicant can waive that was for the applicant's benefit.
Well, your understanding is wrong as far as this administrative law judge is concerned.
Okay. I must have read it wrong.
The point of these sections, the 1701 amendments that were recently done, was to make sure the Commission got the decisions out on time. The legislature was afraid that we were wasting too much time here, or that we were delaying decisions for whatever the reason was, and they put this in, and this is the legislature. So, I don't see how we can meet this 1701.5 by continuing this matter, by just taking it off calendar and letting it sit. Every 60 days we have to put out a new order in this case. Now that reflects only my opinion of the statute. It does not reflect either Commissioner Florio's, or certainly it doesn't reflect the Commission's interpretation of the statute. But I've had a number of these cases before me where I've extended the deadline, and it is a pain in the neck. So, with that, thank you very much. The matter is, the motions are submitted, and we are adjourned. Thank you.